All right. Welcome to the January 16th meeting of the Town of Gorham Board of Appeals. This meeting will come to order. This is a public proceeding, and unless the board specifically votes to go into executive session and ask everyone to leave the room, you have the right to hear everything that is being said and to look at all the exhibits that are offered. Please notify the chairman if you are unable to hear or see. The board works from a prepared agenda, and we'll be considering tonight's items in the following order. We'll have a roll call. We'll have approval of the December 19th, 2024 Board of Appeals minutes. We'll have a pledge of allegiance. And then we will have item 1, discussion for a request for reconsideration. For each case, the proponents will be asked to proceed first and then be available to answer questions from the board. After all the proponents have spoken, the opponents will make their presentations and then be questioned by the board. After all have spoken, each side will be given an opportunity for a brief rebuttal. This meeting is being recorded and it is very difficult to hear what is being said when multiple people speak at the same time. Please refrain from interrupting other speakers. Questions should be addressed through the chair. We ask that each person offering testimony come forward to the microphone and begin giving his or her name and address. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or ordinances. Applicants for variances must specifically address and prove compliance for each of the 4 undue hardship criteria. Following a decision on an application or appeal, toward the end of the meeting, the board will prepare a written decision indicating its findings of fact of conclusions of law that will be mailed to the applicant within 7 days of the board's vote. The applicant is free to stay during the written decision process, but is not required to. If your appeal is granted, you must obtain a building permit from the CEO. If anyone wishes to appeal the board's decision, you must do so to Superior Court within 45 days. Are there any questions about what I have read? Given there's nobody here, no. The agenda for today, as I mentioned, roll call approval of, so first let's do roll call. What did I do with my list here? I see Craig Sterling.
Present.
Dan Nichols.
Present.
Pavel Binzik. Absent. Michael Weissman.
Present.
Gary Baca. Absent. Mark Curtis. Recused and absent. I'm Court Barnett. I will be the chairman for this proceeding tonight. So there's roll call. I will entertain a motion to approve the Board of Appeals minutes from December 19th, 2024.
So moved. Second.
Thank you, Brandon. Thank you, Chair. Again, Brandon Mazer, I am the acting attorney representing the board here in this matter. Pleasure to see you all again. What you have before you is a request for reconsideration. State statute allows any decision of this board to be reconsidered within 45 days of your prior decision, which we are within. That request had to have been made within 10 days of the decision, which it was by the applicant. So the procedure, there are multiple options tonight, but the only thing taking place tonight is your decision on whether or not to reconsider, and it's the board's decision, not the applicant's or anybody else's. So in order to procedurally do that, somebody, and I believe everybody here was in the, it was a unanimous vote, so everybody in the affirmative, somebody in the affirmative would need to make a motion, somebody would have to second that, and then it would have to be approved if you want to either approve or deny the reconsideration. If nobody here is required to make a motion to reconsider, and nobody here is required to make a second. If neither of those things happen, the request basically just dies. You could also motion second to have discussion. That discussion, if you do that, should be limited just to whether or not this board should reconsider the issue. And typically what goes into making that determination is if there is new information that this board did not have or could not have had in front of it at the time of its original decision. So if you do decide to make a motion second, reconsider, and you do reconsider, we need to table to a date certain.
To do what?
Table to a date certain. to renotice. We did not notice this meeting to abutters because it's the board's determination. But if you do reopen it, it'll go back to basically right before you voted, and we would have to renotice that meeting. We will need to do that meeting before February 2nd, which would really mean the week of January 27th, that last week of January. You would have to reconvene to hear whatever new information may be available to you. And just to remind the board, we're not even into the merits yet on this matter. This board decided it did not have jurisdiction on the original appeal. So we would be back to the point of you determining getting additional information or additional testimony, additional evidence to show that you have jurisdiction to even get into the merits. I'm happy to answer any additional questions, but that's the sort of process and procedure, and I'll turn it over to the chair to work through motions or not.
Thank you, Attorney Mazur. Are there any questions?
Yeah, so I have one clarification. I didn't fully hear what you said at the beginning about the applicant wouldn't even be at this meeting. What was that first thing you said?
So it's the board's decision. She made the request for this board to reconsider.
Right.
But that request is just a request for reconsideration. It's really up to this board. It's not a public hearing where they're applying for anything or presenting any additional evidence. Her request is a written request that is in front of everybody that tries to explain why she's asking for a reconsideration. I would caution to look at just the jurisdictional issue that was decided, and whether or not there's new information that you feel is needed to reopen it and potentially come to a different conclusion.
Thank you.
Are there any other questions for the town attorney?
There is no new information, correct? No notice of violation, or
There's been, other than the notice for reconsideration, there's been nothing else provided to the board. The only thing that is new is what was the written request that was provided to the board. That's a one-page
right?
written request.
Are there any motions? Okay. If there are no additional motions, I will entertain a motion to convene.
Adjourn.
Adjourn. Adjourn. Thank you.
So moved.
Second?
Second and third.
All in favor? All opposed?
Meeting is adjourned.